Very good evening to you, ladies and gentlemen. I'm happy to welcome you to the third webinar of Series 6 on the basics of law 2026. This webinar series is organized by the Webinars and Legal Symposiums Committee of the Bar Association of Sri Lanka. I would like to take this opportunity to thank the chairman of the Webinars and Legal Symposiums Committee and the president of the Bar Association, Mr. Rajiv Amarasuriya, the co-chairman, Mr. Chatura Galgani, of the Bar Association, and also the conveners, co-conveners, and the members of the Webinars and Legal Symposiums Committee. I would also like to extend my heartfelt gratitude to the Executive Committee of the Bar Association for all the support and guidance. For today's webinar of Law of Evidence, we have with us an esteemed panelist, Mr. Prashantalal Dialvis, President's Counsel. Mr. Dialvis obtained his Bachelor of Laws and Master of Laws degrees from the University of Colombo. He began his career as a state counsel at the Attorney General's Department of Sri Lanka in 1983 and served in that capacity until 1990. Subsequently, he joined the private bar and practiced in both appellate and trial courts, specializing in the spheres of criminal and family law. Mr. Dialvis has contributed immensely to the legal profession in Sri Lanka, both as a practitioner and as a lecturer in law at the University of Colombo and the Sri Lanka Law College. He also served as a member of the Incorporated Council of Legal Education and as a member of the Board of Studies of Sri Lanka Law College. Mr. Dialvis is well known for his student-centric approach, which has endeared him to the thousands of students he has taught over several decades. He currently serves as the principal of Sri Lanka Law College, having assumed duties in 2024. I warmly welcome Mr. Prashantalal Dialvis, President's Counsel, for today's session. To moderate today's session, we have with us Mr. Tanuka Nandasiri. Mr. Tanuka Nandasiri is an attorney at law of the Supreme Court of Sri Lanka. He obtained his Bachelor of Laws degree from the University of Colombo and a Bachelor of Arts degree from the University of Peradeniya. Mr. Nandasiri has more than 17 years of practice as an attorney at law, specializing in criminal law. I also warmly welcome Mr. Tanuka Nandasiri for today's session. And without any further ado, I invite him to commence today's proceedings.
Good evening, all. I think the introduction given by my learned friend about our esteemed panelist, our senior, Prasant Dajalis, and thank you for joining with us today. And initially, I'd like to invite you to elaborate what is the importance of evidence law. What is the importance of evidence law to a lawyer and to a student? Sir? So you have not unmuted your mic. Sir.
Can you hear me, Tanuka, now?
Yes, sir.
Ladies and gentlemen, thank you again. Thank you, Tanuka, for the moderation and Vidurinder for that introduction. Basically, if you take law of evidence, why it is important is it is important to both civil and criminal practitioners. It is important to both civil and criminal practitioners. We have a small, tiny book that is called Evidence Ordinance, and that has everything that has to do with what kind of evidence that has to be laid. Now, just it is important that we go through the history. Now, most of the principles are from the British law, but incorporated in the Evidence Ordinance. if you take the evidence ordinance of India and Sri Lanka is almost identical. So if you get a textbook, as you know, India is a country that is so wide that in that kind of a context, ladies and gentlemen, if you take it, basically, any high courts, any judge argument, you have a case in India. So this is very important for you to have an Indian evidence book, so that if you want to pursue career in this, it is very important that you get access to Indian law. But in the recent past, they changed the name of the Indian Evidence Act, but the principles are almost the same. So in that kind of a context, Tanuka, it's very important that we have this evidence because it covers both civil and criminal, and any practitioner for that matter has to and must know the basic evidence if you want to practice law.
So you mean that any practitioner cannot go out of the evidence ordinance and conduct a trial?
If it is not available in 100, section 100 of the evidence ordinance says you have to go back to the British law. That is the only thing that you can go back. There is no evidence rules. But then, very interestingly, the judge can ask any questions in 167 evidence ordinance. And in that, ladies and gentlemen, if you take it, it is very important that judges has a wide discretion to ask any questions. Though not relevant, they can ask any questions, but judge has to base his judgment on the evidence ordinance.
But sir, I have heard and I have read several judgments. There should be a limit for this. You can't intervene. You can't intervene into the prosecution case and conduct the prosecution case by the judge. There should be a limit, and that should be limited to administrative justice and to do the justice to the all parties, not to the prosecution, but for the defense also.
Yes, Uncle, though this, I fully agree with you. Thank you for enlightening. I think we should go with this discussion of both together present in this case. Because Tanuka, for that matter, is a very good young person whom I met. I have to confess that I am out of the picture now for the last 1 year, being the principal of Sri Lanka Law College. So let us both do it. I fully agree with you that the judges, there are enough and more judgments that the judge can't interfere in the course of the justice. It would be regarded as bias. But generally, a good judge will ask those questions at the end of it, isn't it, Tanuka?
Yes.
After prosecution is over, defense is over, then judge will ask those whatever questions. Otherwise, all the best judges never disturb the counsels of both prosecution or defense.
So since you start to discuss about the judges, there's a provision in the criminal procedure code where if the prosecution fail to call any witness, generally the defense can call. But
Yes.
section 119 says if the defense can ask or the request for the judge to call that person as a witness of court
Yes.
and allow the defense or the prosecution, if necessary, to cross-examine.
Yes. Yes. Yes.
But the
Those
problem
are
is
very wide powers that is there to create justice, Tanuka, isn't it?
yes.
Yes.
The problem is when we make that request from the High Court judges, generally they ask us to call that witness from our side, from the defense side.
That's the case. That happens there because generally some judges are prosecution minded and they want us to basically call the evidence because that's a discretion court has. But I don't think a good judge should do that. What is important is to create justice, is the discretion that the judge must use in a section like that.
Yes, there's a specific judgment from Justice Ranjit Silva saying you have to call. But when we cite the judgment, sometimes the judges are reluctant to admit it and ask us why don't you call? You have a right. You can do it from your side.
Exactly. Exactly. I fully agree with you. That's my personal experience too when I was practicing.
So, when we applying the evidence ordinance for criminal cases and civil cases, it's a difference.
Yes, but in special areas, there is a clear difference. I will take admissions and confessions, and that is section 17(1) and 17(2). Now, there is a very clear law difference about a confession is the thing where you admit guilt. So, from there comes section 24, 25, 26, 27. 24 is about a statement without inducement, threat, or promise that is given to a person in authority. Confession applies to the police officer, excise officer, and a forest officer. And 26 applies when they are in custody. Now, those are specific laws which is relevant to the confessions, which we can discuss details later, Tanuka. But admissions, if you take it, is common to both. So when like the case of Ananda Goda, when it is facts about motive, previous conduct, subsequent conduct, not confession. Confession means, according to Ananda Goda, that admitting that I have killed. The rest of it, if you take it, basically like relevant facts, like motive, previous conduct, those things are considered admissions and can be used against the accused. So this distinction is very clear. Admissions apply to, like, if I commit adultery with a woman and I admit that with my wife or with you, Tanu, that can be used as evidence because that can be used against you, not for you. Very interesting. Admissions can't be used for you because then you can make stories and say anything. It can be used against you. So I think that's the first distinction. Second one is in character. That is section 53 to 55, 52 to 55, where if the accused character cannot be led unless he brings good character. So that's another area. But other than these two, generally, relevancy, documents, all applies to both civil and criminal. Only these two areas are more criminal in nature. So that's the scenario, Tanuka.
Sir, can you elaborate us on admissions further? Because the law relating to admissions under Prevention of Terrorist Act is something different.
Prevention
So,
of terrorism.
yes, Prevention of Terrorism Act, sir. There the confession is different. Under section 17, that confession can be admitted even against the court accused also.
Definitely. Now, what is Tanuka pointing out, my dear ladies and gentlemen, is an emergency or a terrorism scenario, isn't it, Tanuka? What you are
Yes,
referring?
yes.
Yes. Now, that is where, very interestingly, section 16, if you take the Prevention of Terrorism Act, that beautifully combined a confession made to a ASP and above. Now, you have to understand, in a terrorist situation, nobody wants to come and give evidence. So it's very, very difficult to find a witness. So we have to, the law or the system must find a way. Now, in that kind of a context, in section 16, they brought in this confession made to a ASP and above, but putting the 24 thing into it by saying it has to be complied according to 24, which is without inducement, threat, or promise of a temporal nature, laukika. That has to be something not in the next birth, that you will be born in a nice place, heaven or hell, kind of thing. It has to be inducement, threat, or promise about something in life, tangible, like in life. So those things is a combination, like what Tanuka said, ladies and gentlemen. It is very simple that you can have admissions coming in. I hope I have answered you, Tanuka.
Yes, sir.
You can express further. I mean, I suggested to Tanuka, ladies and gentlemen, we will have a chat. Because Tanuka is a very well expert lawyer. So if we have a chat kind of thing, kind of a discussion, the best thing will come out of both of us. So you can add anything, Tanuka. It is not a
No,
question
no, you
kind
have
of a
elaborate on
model.
that, sir, on that point, sir. Sir, when junior lawyer start to practice, what kind of areas we have to initially cover? I think that is also very important for our junior lawyers, as you as a senior and the president counsel and also the principal of the law college. So, what kind of areas we have to initially cover? Oh, we have to master in everything.
Tanuka, if you are a magistrate court practitioner, it is very important to know about the relevancy in the trial. Because, I mean, most of the skill comes in a lawyer in magistrate court. You have to understand. Because you, in the magistrate court, you don't get the first statement. You get the first statement under section 444, and you get a statement of the other person. But in a high court, you get all the documents. So it is very important that you learn, because you have limited resources. The first complaint and a statement that is relevant to the charges. So, and in court in 444, you can make an application to court to peruse any other statement where the judge decides, in the interest of justice. Now, these are the limited resources a magistrate court has. So young people like you and I, when we all started, if you want to do criminal, we started in the magistrate court. So there are the most important things are about relevance, content marking contradictions, because is 145, 155, where it is previous statement is inconsistent. Where these are the little things that you must master, like character of a prosecutrix, that kind of 145, 155 are the sections that you must master. How to mark contradictions, how to mark omissions, because omissions are also contradictions. So young lawyer must and should look at this marking contradiction from statements. To me, like expert evidence and bad character and documents are important, but it is not critical as a person. So you have to, I believe, which I did when I was in the magistrate court before I joined the department, was these statements: how to mark contradictions, how to mark omissions, and basically the relevancy would be the area that you should cover as a junior. What do you think, Tanuka? You are a young lawyer, very strong
Yes, sir.
young
And
lawyer.
I
What did
have
you
seen,
do?
yes, I have seen in several instances, we put the question and we tried to highlight the contradiction, but we fail to mark it.
Yes, yes, quite so. Now, this is a art, no, Tanuka. There is a book called The Art of Cross-Examination. This is a skill. Now, that is what we, at the law college, we are trying to do with moods. Now, we are trying to get, kind of stimulation of a trial and then try to mark contradictions. Even after taking oaths as a lawyer, now we are apprenticing, are going through a clinic or a workshop where they get training on how to mark contradictions. So, in my life, it was a skill. Now, when I was a state counsel, we rarely get a chance to mark contradiction because accused don't generally come to the box, even if it is doc statement from the doc, not coming to the witness box. So we never had a training, even as a state counsel for me for 7 years, to cross-examine. So you must, as a junior, get the possible chances and learn this art. It's actually an art. Because if you take marking contradiction, today people will say, "But I can't remember." Then you must be very skillful, going around the bush පටේට ගිහිල්ලා. Go around and somehow fix it. Because today witnesses are very smart. They would say, I can't remember, I have forgotten it. So then how to get it? So likewise, we have to be very smart, street smart, on the feet, because we must understand criminal lawyer. If you look at criminal lawyer and the civil lawyer, may I say, Tanuka, I just want to make a comparison with your permission. And Isuri, if you take it, criminal lawyers are generally ending up as politicians. If you look at politicians, even this parliament has so many, and even in the past. Why? Because we have to take quick decisions. We have to work as criminal lawyers on the feet, marking contradiction. But in a civil case, it's about documents and so many other things where you can get ready and come. So criminal lawyers generally end up in politics. Again, I repeat, I like to say a very personal quote. Now, I am in the corporate sector. I'm a director of companies. So, a lot of people ask me in that kind of a context, ladies and gentlemen, how did you become a corporate director? Now, this question I asked another criminal, that is my father, who is Chairman Sampath. He said very interestingly, we as criminal lawyers have to think on the feet. We have to plan on the feet. When we are cross-examining, we should know what is the answer which is going. And also we need to know what is the answers of the other witnesses who gave evidence before. We will need to know the answers that is going to come and how to ask. Because in cross-examination, we can ask leading questions, Tanuka, in cross-examination. So, all that has to be taken in a very quick, fast decisions, unlike civil lawyers. So, we in the corporate sector take decisions on facts. So, how to elicit facts, how to take a decision, best one is to criminal lawyer, Tanuka. This is what I found in the corporate sector. I, as a criminal lawyer with that background, I am in the corporate sector thanks to this skill. Contradictions, omissions, how to lead evidence, that and decision making, fast, helps you in anything in life, even marriage, Tanuka. Sorry, I got out of the topic of law of evidence, but what I want to stress here is, as a criminal lawyer, you have a vast area of skill in life also, as a husband, wife, child, how to handle a child. All that comes being a good criminal lawyer. Sorry, I went a bit out, but I'm passionate to say this.
Since we discussed about contradictions, so when we mark a contradiction, I think we should have a special and separate note on that, because we have to prove it at the end.
Exactly.
Generally we forgot to do that. When the relevant police officer who record the statement comes, we have to put it to him and prove it. But we get to know that witness has passed and he has already given evidence and gone when we come to the defense case. Therefore, we have to have a list and a separate note on contradiction, and we have to put it to the relevant officer and prove it before the prosecution close the case. So I think I have seen in several cases contradictions have been marked but have not been proved at the end.
Tanuka is perfectly right. Contradiction has to be proved. Omission has to be proved. But very interestingly, sometimes it has happened to me also when I was young. Then, of course, we get a chance to call the witness as OIC and mark it. And then the question is, the other party get a right to cross-examine. That's disadvantageous to you. They can catch up things that they missed it in the previous. So, as Tanuka says, try to mark it when the prosecution is leading that police officer. Otherwise, if you miss it, Tanuka, in my life also I have called what to do if it is a very vital contradictions, important contradictions. In my life, I have called them as a defense counsel, as a defense witness also, but it's a running a risk, no? Other party
Yes.
can cross-examine, no? So that's a very interesting thing Tanuka spoke. Yes, Tanuka.
Uh, if the prosecution has missed something, they can cover it after when we call that witnesses.
Exactly, Tanuka.
So when we analyze the judgment in criminal appeals, uh, what are the areas we have to think about on evidence law? Whether whether the judge has evaluate and analyze the credibility, or whether the other principles of evidence law have been analyzed properly by the judge. So what are the areas we have to think and we have to keep in our mind when we read the appeal brief?
Very good point, Tanuka. If you are doing appeal, I like to stress what Mr. Colvin is one of the best appeal and a trial law. Some appeal lawyers are not good trial lawyers. Some good trial lawyers are not appeal lawyers. Mr. Colvin De Silva, Dr. Colvin De Silva is a person who did both. Now, we were, Tanuka, very fortunate to be taught by him, to see him. Sadly, Tanuka, your generation and the generation below has not seen him. Now, so therefore, I will say that he says, when you take the brief, just first go through the brief very fast from page 1 to last. Very fast. Don't think, don't stop. Then you get the whole idea. Second one, you start from the judgment. When you look at the judgment, then you grasp what are the mistakes that he had done. And then you look for in the evidence, because in court of appeal or any court, you have to be arguing, ladies and gentlemen, arguing that the judge had made the mistake. Now, there are two things that you can do in a case where judge has not, in a jury trial, the judge has to do is summing up. Now, court of appeal is very, very careful in a summing up because you are addressing the jurors. So where you have to be very, very careful if whether he makes a slight mistake. But in judge's case, where judge has written the judgment, like Tanuka said, we need to look at the mistakes he had done in law of evidence. And whether, now, I mean, all these sections it has created the prejudice. Created a prejudice in the case for the accused. So there is a critical one. Just marking some simple thing won't do. So you have to have a very inquisitive mind, a CID kind or a investigating mind, and trying to see what are the judgment in the judgment, where has judge has fallen. Has he checked up the contradictions? Has he analyzed those contradictions and omissions? And whether he has written something irrelevant. Now, earlier, as Tanka and I pointed out, there is a discussion for that to ask questions. So, after asking questions, has he used irrelevant ones? Because there is section, very 166, where you give the judge full discretion. Abhimatya. There is very clear that he can't use anything irrelevant. It has to use relevant evidence. So in that kind of a situation, it is your pertinent duty to... Can you hear me?
Yes, sir. We can.
Dilan? All right.
Sir, we can hear you, sir.
Open camera. So in that kind of a context, in that kind of a judgment, you need to and you must look at those ways, Tanuka. What do you think? What would you do, Tanuka?
Generally, sir, when we get a brief, I go through the judgment and try to find out whether the judge has properly evaluated the evidence of the main witnesses and whether he has evaluated on the credibility of the witness. And thereafter, I try to go through whether he has evaluated on the interestedness of the relevant witness, whether is interested witness on the crime or the virtual complainant.
Very
Those
interesting.
kind of
Different approaches, ladies and gentlemen, it is different approaches. But the key factor, like Tanuka and I said, you have to know the brief from page 1 to last. And that is exactly what Dr. Colvin Silva said. He would at least read 2 times, 3 times, make notes, and he's ready. So in the previous day, he would only just go through the notes and be ready. So he is a person who worked very, very hard, diligently. And anyone who paid these fees is fully worth.
As I'd like to comment on Kumaraswamy's work, because I think that is also a good book to read. And sir, what do you think about that? Because in the Kumaraswamy book 2 volume 2, there's a specific chapter on that, on how to evaluate and how to consider the case by the judges also.
Of course, as Tanuka pointed out, as young lawyers, when you have money, you must buy Kumaraswamy volume 1, especially in the first phase. And then go on buying second, third, it's about reforms. So I ask you, ladies and gentlemen, to invest for books whenever you have little extra money. But that brings you money. That brings you income. So as Tanuka pointed out, Mr. E.R.S.R. Kumaraswamy is the best for point at that time. But there are Indian books, no, Tanuka? If you can
Yes,
get
sir.
the latest to support any argument, because it's the same evidence ordinance. We have some law in the evidence ordinance. So that is very, very important. Also, if you're concentrating on appellate work. But if you're only doing trials, just Mr. Kumaraswamy's book is more than enough.
I couldn't inform our participants that there's a small box under the advice table. There's a Q&A name. If you have anything to ask from our eminent senior, you can put any question on that, and I can put it to sir directly. So I know that you are master in criminal, but we have to do it. We have to justify our participation for our civil practitioners also. For them, can I put to a question which is relevant to civil practitioners also? Because even in criminal cases, we have to mark documents. But in
Yes.
criminal laws, there's there's no room to mark those documents under subject to proof. But in civil cases, we have seen, and even there are judgments related to that. Sir, you have to mark documents subject to proof. So, what is the different mark in documents in both areas, in criminal and civil?
Now, in criminal law, we know that first complaint can be marked. But other than that, any other statement of criminal law can be only used to mark inconsistency or contradictions. But in civil case, now look at an accident case, confession made to a police by the driver is not valid. But in the case of compensation, if you are asking for damages and if you file a case within 2 years, that can be used as a document, not to mark contradictions. So that is a very critical one that is there, like what you mentioned, Tanuka. And then what is this subject to proof? It's about primary evidence. So you have to be very clear about what is secondary evidence and what is primary evidence in the evidence ordinance. Now, what are the primary documents is the original document itself. Now, imagine if the original, now I write a letter to Tanuka, now Tanuka has it. So, I have to ask Tanuka to bring it. How you ask it? Section 66 notice of the evidence ordinance. You ask Tanuka to bring it to courts. Now, if it is not there, now these things comes in. If it is not there, then we have to basically use secondary evidence, certified copies, notes that was made, photocopies. Now that's very interesting. Photocopies has to be looked at the beginning, that, and then and it has to be marked as a true copy, accuracy of the original. And like if it is like a Sila Lekana, the whole kind of a stone which you can't bring into court, like tombstone, if you want to prove a man is dead from the Kanaka, then you can't remove that, then you can take a picture and bring it. Now, those are secondary evidence that can be marked, provided original is destroyed, cannot be brought to courts. Look at those sections from 61 to basically 65, all that is there. So that is there, but then in criminal law too, Tanuka, in a case of misappropriation, in case of criminal breach of trust. What is criminal breach of trust? A storekeeper is given food, things and it is stolen. It's not there when they do an audit. Now, then you have to base your case on documents, even in a criminal breach of trust. Now, in the latest, they brought in a case. If you write a check and there is no fund, it's a criminal loan. So that very clear. Earlier too, we could manage with Debt Recovery Act, but now it is clear that you are liable, criminally liable. So those, even a check is a document. So you need to have the primary state done. But if it is not there, but certified copies, you can always mark. Certified copy is a copy that where it is in the state and people have access to it. And in that kind of access, you can ask those things. Yes, Tom.
But sir, in criminal case or criminal trial, there is no principle or practice saying marking documents under subject to proof. But I have seen several practitioners allow or to move court to mark documents under subject to in criminal cases also.
Yes, basic principle as we started, Tanuka, is about criminal and civil documentary. It's a common thing to both. Whatever it is, if there is no original thing, document, when you are marking, the other party can say, I object. Then better to say subject to proof. Proof means it has to list of witnesses even in the indictment. There must be a list of witnesses who will bring this document to court in the custody of someone or by section 46 notice. In the High Court, of course, we send notices through the court. So whenever there is no original to mark, then original is the primary evidence. Then it is subject to proof. It doesn't make a difference in criminal or civil law, Tanuka, isn't it?
Yes, sir, but there's a small difference, I believe, sir, because in criminal cases, if you fail to mark the certified copy or the secondary evidence or the original, that cannot be considered at the end. But in civil cases, if you fail to object for that document which was not marked at the trial, not proved at the trial, can be considered by the judges.
Okay, that is very interesting.
That difference is there, sir, but that is why I put that question, sir. In criminal cases, if the original or a certificate is not there, no point of marking marking a photocopy or other documents. Sir.
Okay. But
And
I
sir,
still be. But Tanuka, if it is
yes,
destroyed, now we find in courthouses things get destroyed, no? Then we mark
yes.
photocopies, no, Tanuka.
That is why, sir. That is why I want something from you, sir. I have seen sometimes the registrar are called and lead the evidence that the registry or the relevant document is destroyed and mark the documents which was prepared subsequently.
Yes. Now, if you are giving statements to the originals to the CID, very interesting. They have a printed form, Tanuka.
Yes.
They will fill up that and take the originals from us. So then I always advise my clients, keep the photocopies with you. keep the photocopies with you, because then it is secondary evidence. If the CID says that is destroyed, then we get a chance of under the evidence ordinance to bring in those documents. Otherwise, the original is there. Now, very interestingly, in a criminal case, original is required because it is you have to send it to EQD and so many things if they challenge the authenticity of the document. So those weaknesses are there in a criminal case of a EQD, especially if it is a case of cheating or documentary cheating or whatever case. I
Since we
apologize
have-
if there is a disturbance of, there is a period going behind, ladies and gentlemen. I'm at law college, so that's a thing which is beyond my control. I hope it doesn't bother you, Isuri. And
No, it's all right. So since we have spent more time on evidence ordinance, there is another important part of the evidence ordinance, specific amendment, evidence special provision act. Not actually
yes,
not amendment, that's a special provision act. So there is a special procedure once you mark electronic evidence.
sure.
Can you elaborate on that, sir?
Yes,
Because
Tanuka. Yeah, today, Tanuka, everything is CCTV cameras, so you can see how they are arrested in Jakarta, Indonesia. And so you don't need police officers' evidence that you can only play the CCTV cameras, how he was arrested in Jakarta. So this becomes a very, very critical, important thing. Now, ladies and gentlemen, when you have CCTV evidence, if prosecution is going to prove it, or for that matter, even a civil case, any party who is producing a CCTV camera evidence or electronic evidence or a video recording or even audio recording, you need to give 45 days notice to the other part. So what we generally do is we file it in the courthouse and give notice, because very interestingly in Gampaha electricity board case, I did appear. I went on the single act. Now, if you look at the single act, it says you file in the court and give notice. But I did other way around, going by the single one. Sorry, the English one. Single one says it's open where you can send the notice and later file in court. Now, this both has to happen. Now, it went to the High Court and we argued and we succeeded. We succeeded about this. So that, it doesn't mean, because what is most important thing is giving notice to the other party. Why? Other party can within 15 days can ask these video recorders, the computers, to be inspected by them. So what we do is, generally, now I'm not expert, we sometimes hire an expert, maybe a junior of yours. If you are a junior you are very good at it, you can go with a fee. But otherwise, I send my junior with an expert on IT who is outside. So then we checked up, and then after that only they can lead evidence. Now, in the latest case, Justice Priyantapane wrote that when the State Council failed to give notice in a case, in a prosecution, they can still lead it. So I personally don't agree. That's a very progressive one where this, even without giving notice, if you later show and give inspection, that is enough. So lethargy has no play in that. So this is very, very important. And now the latest thinking is, now say I want to lead evidence of CCTV. There is one school of thought which says that I should get a report from Moratuwa University saying that this authenticity, this is the correct and proper recording. Now, this is the latest argument that is going. So, if you are really keen on this case, You can even put this video recording and ask the court to submit it to the Moratoa University and get an opinion. Maybe you have to pay a fee. Court may not agree, but it is still worth to try that. Because that's a new school of thought which coming out and says, no, you have to prove the authenticity. You just can't give notice and mark. You have to prove scientifically as your own case that you have to prove that this is yours. This is authenticated. So it's a very interesting debates happening these days. But best is to be very safe, give 45 days notice and get a recording checked up by the Moratoa University. That is original. It is not tampered. It is the original from the camera or phone that have been taken.
So can we do it in our own, or we have to go through the court process?
Very interesting. We have to go through the court process. Now, I have always a problem with this our system of criminal of justice. If you take the 123, 123, 124, 5, 6, 7, even a confession made to a police officer, identification parade, it is all for prosecution, no, Tanuka. If a defense counsel wants to get expert evidence, look at my accused, injury on my accused, there is no provision for a right for the defense. 123, even I mean nothing. So we have no power unless judge concedes and call for that. So it is a very big lacuna which is not yet covered. It's only for the prosecution to get assistance from the judiciary, from the magistrate, that you have this scenario. So if we are for the defense to ask the court and get this notice, might have a problem. But if it is a prosecution, certainly there is an opportunity under 123 to 127 of the Criminal Procedure Code.
So when you mark electronic evidence, there's two schools. Some says no need of affidavit, supporting affidavit with the notice, and some says there should be an affidavit supporting the documents. I think there should be an affidavit. I believe. What do you think, sir?
I fully agree with Tanuka because you must have affidavit now. Otherwise, how now? Otherwise always the witness will produce a document. He will come to the box and produce. Now this is a situation where we want to facilitate, support, and try to bring this kind of evidence. And when it is done, affidavit is allowed under the Special Provision Act number 14 of 1995. So in that kind of a situation, you must have affidavit because that's the way, unfortunately, you can even then ask to cross-examine if the other party agrees. But this is very, very important, ladies and gentlemen, for us to bring the evidence in. I fully agree with Tanuka. You need to have a way to come in. You just can't throw a video, throw an audio recorder. You must have a way to bring it. And a possible only way is evidence through a witness. And if it is not, you must have an affidavit from an expert who will verify, who will say this is the original, who has, verify this situation, who is in custody of that, say, compute evidence. One who is in custody of this has to give that affidavit. Otherwise, where is the legality? There is an authenticity. So I am also with Tanuka, agree that it has to have an affidavit.
So we have seen as in practice, sometimes defense counsel agree to the documents or without any basis object to the documents. Sir, but in several instances we have seen the defense get the opportunity of experts to check the devices and the videos.
That is the case now, Tanuka. I'm not expert. I only can send an email or suddenly do SMS. So I need an expert to go there. If it is a very complicated computer evidence, now good example, Computer Crimes Act, and you take the Data Protection Act and all that, even Electronic Devices Fraud Act, number act about credit cards. Expert goes with the police officer to arrest, to take the systems into it. So if that is the case, why not we defense counsel has an opportunity to bring in a witness who is an expert to go to that place? I strongly feel in the field of justice, the court must take that step. When we make an application to court, in order for justice, yuktiya, justice, we must and should have the opportunity for the defense to present the case.
So again, if the defense want to lead evidence, electronic evidence in his case, whether we have to give notice prior to the commencement of the entire case, or whether that should be done before the commencement of the defense case.
This is about electronic
Electronic
transactions.
evidence, electronic transactions, and
Yes.
not only the transactions, electronic, not the electronic evidence actors.
That's right. Now, you are referring to whether you should give a prior notice, right?
Prior notice, 45 days prior notice before the commencement of the main case or the entire case, prosecution case or the defense case.
I am of the view that it has to be done basically before the leading of evidence. But question arises if it is a day-to-day trial, judge wants to have it in a day-to-day, very close days, today, next week. Now how? And therefore, in that kind of a situation, I believe we should have given notice at the beginning. But if it is a lengthy one, which there is enough time period, then what is wrong? What is illegal to give 45 days notice before leading evidence? So I would take the situation depending on the circumstances. If the judge wants to start and end the case fast, like the 3 judges bench who will probably hear day-to-day kind of thing, then it has to be given notice. Now, in my experience, my last case, the largest bribery custom case, notice were given by the state at the beginning of it, trial. So we sent our experts and were ready. Otherwise, there is a problem of day-to-day close dates in the trial. So I think it is very vital that that there is no unjust thing happening. In that kind of a situation, it is must be given before the trial commences.
The problems are we ready for our cases. As a defense counsel, we get ready for the defense case after the prosecution close his case. But I believe we have to get ready before the commencement of the main case. Then we can decide what we are going to do and what kind of evidence we are going to lead. That is why our juniors and actually our colleagues decide or struggle to give notice after the prosecution case. As you said, sir,
Yes.
if we have a plan, we can do it even before the commencement of the main case, prosecution case.
Of course. But now Tanuka raised a very valid point, ladies and gentlemen, being young lawyers. Not only in this electronic transaction, I'm sure Tanuka will agree with me that, any case you have to be ready from the beginning. Because what I have seen in the appeal, I'm sure Tanuka being appellate lawyer knows that we need to suggest our position in the witness. That's the latest trend of thoughts in the Court of Appeal. You just can't suddenly, good old days when we were doing prosecution, they would put a surprise witness and take a total different situation. Without suggesting, say, private defense, Atma Raksha, private defense, they would suddenly take private defense. With the witness, they won't raise it. They won't ask questions. They won't even suggest. So I'm sure, Tanuka, you may have come across a lot of judgments in the Court of Appeal that we have to make those suggestions now at the beginning. And the Elembaro dictum also is some judges are using that when a prosecution has made a prima facie case, if you don't show evidence, then adverse inference is taken against you. So some judges are using it, isn't it, Tanuka, in the whole scenario? So you have to be prepared from the day one. You just can't go today and a witness, tomorrow another witness. I'll get ready for one witness. No, that will not work. Especially in the appeal, you will be criticized that the lawyer who did the High Court or the Magistrate Court did not do the job properly, like asking suggestions on that line. So these are very important for young lawyers to understand that suggestions, positions, all that has to be taken from the beginning now. You just can't suddenly surprise, get up and take a different position. Am I right, Tankar?
Yes, sir. Your exact point has been analyzed and explained in Gunasiri versus AG, I believe 2009 SL. Justice Israo. He has categorically said you have to put it to the main witnesses if you want to take it at the defense. That is there.
Yes.
And sir, we are taking different defenses in the same case. I have seen, sir, we have taken 3 defenses, 4 defenses in the same case, which are not going collectively but contradict each.
That is where I'm not prepared properly, no, Tankar. When you are not prepared, you today get up and think, today is the grave and sudden provocation, we will take that up. So it's a mitigatory offense. And then you decide it is private defense. But you may see both together in a combination. Now for that, it is very, very important that you get ready. You think. Now in our case, when we were young, I'm not saying, Hane, ape kale young, you are not Kela, right? I'm not saying that. But we used to, even as state council, I'm ever grateful to the department for giving me that training. We used to think different situations and say, what is the best defense I should take? What kind of a position that I must take in this situation? So in that kind of a context, we have to plan. I mean, very simple scenario is planned. Now, good example, I'll just tell you one example, very interesting example. Now, I appeared for Uduwe Dhammaloka Aliyah case. It was about possession. No, everyone knew Hamudro was in possession, Hamudro was feeding, right? So I was not asking any questions. I only asked whether there was another old monk who is the Viharadipati. Did he object to the vehicle being taken, vehicle taking the Uduwe Hamudro, elephant? The witness said, of course, yes. Why? In a temple, all things like including a kumbia belongs to the Viharadipati. Now, from the beginning, I know this is my defense. Uduwe Dhammaloka Hamudro was a resident monk. He can't possess anything in the temple. So I knew from the beginning. So I don't ask unnecessary questions. When the doc statement came from the Hamudro, because Attorney General's Department, Tanuka is not aware of the Buddhist and Temple Act, no Viharasa Devala Panata. So they are not using that, they are not aware of that. So I just told the Hamudro in the doc statement, with Prakasha, say the truth. What is the truth? That I belong to the court Parsha and the other temple is Amarapura Nikaya. And the Mahanayaka Hamudro is that. So my position was very simple. If there is an Aliyah and if it is not in the position, the Hamudro, only the Viharadipati can say, I am not the possessor. Santak. So, no statement was recorded, not evidence was laid. So that's my case. So from the beginning, you have to be ready with your position. You can't change. Of course, you can change that halfway if there is a turn. That's what I at the beginning said. Criminal lawyer is a person who is flexible, flexible, and move like thunder. Now, you could recall, Natanka, you and I did a case, a very interesting case, documentary case, right?
Yes.
You were playing things, right? I was playing things, but then it went out. So it was very interesting. That's why I admire Tanka. I mean, he was a very smart young boy at that time. We were playing the game. Law, criminal
One
law.
case is still going on, sir.
Sorry?
One is concluded, the other one is still going on, sir.
Okay.
So your illustration make me to bring you to thousands of areas, but we have limited time. But anyway, sir, uh, our lawyers believe the cross explanation should be very short, and sometimes some says no, we have to do it whatever we can. We have to ask whatever questions we have to ask. So, is there a limit of questioning, or how can we decide on the length of the cross explanation, sir?
No, there was a lawyer in Gampaha who was asking contradictions and marking in numbers. So I remember one judge saying to that lawyer, this is not a cricket match to score points. It's not a score, no. We must ask a contradiction which goes to the core of the case. Not do a hurried matter. Core of the case. We just can't ask many things. How can a person remember what is the color of the shirt he was wearing? Now he might say blue, thing might could have been black. Right? How can you, I mean, in a criminal case, I always as a state counsel, for the fun of it, let me explain this one. Now, my dear friends, this is a 100 rupee note. No, I'm going to show you a 100 rupee note, right? In the 100 rupee note, now can you tell me without looking at what is there in that note? No one knows. But look at it now. We have a bird, right? We have a butterfly. On the other side, we have girls dancing, the Tamil dance, right? Now people will remember only important things now. So you have to be very sharp. Mama Anantavad, I've seen many times you are going to try to pin a point, right? And what happens? You get into a mess. Now, if you are cross-examining, please remember the other side can only ask in re-examination what you have cross-examined. I repeat again, the other party can ask only questions that go through the evidence ordinance, leading questions, cross-examination. That is very clear. In re-examination, only you can ask what other party cross-examine. If you go there, ask all, I want to show my client a lot of things that I did, a lot of questions, you may expose the client to a danger. There may be a re-examination from the other side. They have forgotten, they have missed it. They may come in. So you have to be very smart in cross-examination. I fully agree with Tanulaka there. You don't need to ask major things. Tanulaka, if there is a time issue, I will just try to raise two issues only. Are you going to touch on Electronic Transaction Act?
Yes, sir, better if you can, sir. If you can
Yeah, I'll do that.
elaborate on that
Now,
also.
this is very important in today's, in the Electronic Act, Transaction Act of Sri Lanka in 2006 brought in validity to electronic transaction, not to immovable land, not to last will, and many things. You can look at the section 23 of the Electronic Transaction Act where you cannot apply. Otherwise, electronic transaction is part of our government, both government and this. Now I want you to understand, they are very categorically says, evidence ordinance will not apply. Special Provision Act will not apply. Very clear. So for all what we discuss now, if it is an electronic, what are electronic transactions? You are ordering a Uber, you are ordering a food. I'm just giving you a simple example. That's an electronic transaction. So they have not provided. You are going to sue the Uber. Evidence Special Provision Act does not apply. You don't have to give notice. Why? Because they have to give recognition to the Electronic Transaction Act. Now, very interestingly, in the same year, for to give validity to the credit cards, they brought in an Act of Payment Devices Fraud Act. In that, they brought in very interesting presumptions. I have never seen this. If you keep a false credit card or a machine, you are presumed, I repeat again, you are presumed to have committed to keeping it to commit an offense. Very interesting, the other one, 28 section, which says if you have not paid the credit card money in full, and you have changed your address and not informed the credit card company, what does it say? You are presumed to be cheating the issuer. These are presumptions that were not there in the evidence ordinance. We, the system, never believed you can presume that you have stolen when you have a gadget. It's like I have a gun and I am presuming that I am going to shoot someone. Possession of a gun is different. No? Shooting a man is different. Here, total different. And if I don't pay full amount and I change the address, that means I'm going to fraud. Now, why? They want to give validity to the credit card. So, even basic evidence laws has been changed. So, those are the two areas that I want to stress, Tanuka, with the technology which is changing dramatically. Now, Justice Chitrasiri in the High Court has decided SMS is evidence. So if we are getting into a different world now, and I still don't know how we can face AI, artificial intelligence, in this whole game of evidence, because it is creating an amazing thing. Now, there was a situation where one of my juniors went and found judgments and a kind of thing for written submission. Those were not actually ones, because when you upload, that becomes part of AI. So a false thing by someone else become part of AI. So very not even like Wikipedia. So this is a new era, and this is young people must and should look into the laws of this, because like Anti-Corruption Act, most of the people are arrested due to Money Laundering Act. How to prove money laundering when there are, is in the bank accounts, foreign accounts. So those laws will now come in. Electronic Transaction Act will come in. And so this evidence ordinance does not apply, and Special Provision Act will not apply. So you have to be now ready, young boys and girls, to face this situation and learn these laws also in addition to the evidence ordinance.
So since you mentioned about the AI created judgments, we have to be careful even we are citing judgments of research papers. Because I
Yes,
had the same experience. We cited several judgments from the research papers. But those are
yes,
also created from AI, sir. Those are not real.
sure.
We believe research papers downloaded from several even not fully recognized, but recognized websites. But
Sure,
those judgments also not real.
sure.
So we have a question from our participants. Uh, he has asked if we have to prove a document from a bhikkhu or a religious person who is reluctant to come to court. Is there a procedure to mark that, the prove that document without calling him as a witness?
Very interesting question. Anyone is not sacred in the court of system. You can't be reluctant to come to courts. Only affidavits are used in civil, in injunction, in the district court, injunction, stay orders. Those are the only laws that provides for affidavits to be evidence. Of course, in the High Court, in the writ matter, you can have petition and affidavit. Fundamental right you have entrusted with petition and affidavit. But our law does not provide evidence for a witness not to be there. That is there only in section 32. When witness cannot be brought to court because of sickness and everything. And if he's dead, cannot be brought to courts, as I said before, and is without undue delay or anything. That is section 32. Then we can use his statement against him. His statement only. Not against him, dying deposition. Marnasan Prakasha. That is brought in under section 32 to prove the case there. Other one is 33. 33 is about basically former proceedings. Now, very interestingly, former proceedings can only be led, I'm just going one step further to the question, can be led only if it is the same issue, same parties, and very importantly, the right and opportunity to cross-examine. Right and decamone, both is required. Opportunity to cross-examine in the previous proceedings. Now that is like inquest, not there. Today's case, non-summary not there in a murder case. But otherwise, say a maintenance case. If it is cross-examining, accident case, whatever it is cross-examining, can be used if the witness is not there due to death, undue delay, you can't bring him to justice. He's so sick, he can't do it. Now, that is former judicial proceedings. Earlier 32 was a statement. No evidence can be brought in a criminal case, definitely not. Unless it is a bail application. Bail application, we can find Buddhist monks saying, he's a good dayakane, he's so nice, so he has a good character. That kind of thing can be used in a bail application, but not as substantial evidence. Tanuka, anything to add, Tanuka? What do you think?
With this electronic era, whether we can lead that evidence, we can lead that evidence through Zoom or something, sir? If you're reluctant to come to court, can we move court to lead that evidence through electronic means?
It's like this now. Good example. Today, our recordings. Imagine you or me, Tanuka, has contempt of court case. Now that will be against me. But how can I bring in for me? How can I use this recording to support me in a case? Of course, yeah, it's a previous statement made and all that. But any lay witness, it is hearsay, Pravadaka Sakshi, hearsay. So you can't bring in with the affidavit. Now, how to cross-examine? Where will that right go, ladies and gentlemen? Where is the right to re-examine? That is not available. So you can't use that.
But I have went through a judgment, actually district court judgment. Our learned judge has allowed to lead evidence through Zoom because actually the witnesses available to cross-examine through Zoom, sir. He has given part of the evidence. Examiner chief is given in open court, but thereafter he has migrated. Subsequently, then application has been made to cross-examine or to lead the other part of the evidence through Zooms. That was allowed.
Yes,
I don't know
now
whether it
Zoom,
has been appealed, but I read the district court judgment, sir.
certainly Zoom is very critical. Now, if you go to a court of appeal, accused are not brought no courts, they are listening to, because the appeal must be heard before the appeal. No? So there is a screen. And you can see accused is watching us. Tanuka, am I right?
Yes.
If you come to court of appeal,
Yes.
107, all those courts has a screen. And the accused is hearing all what I'm saying. Right? So, but he's not there. So very interesting case happened in Dr. Pratapji's case in India. Now that's where the Zoom evidence came under the Criminal Procedure Code. Because we have to have a very interesting situation where the accused has to be, our law says, evidence has to be led in the presence of the accused. Now, that is the case. So, whether Zoom is the presence, that's the issue that came up. Very interesting. I like that statement. They said, if you are watching a live match, now, these days, Zimbabwe and Sri Lanka is playing cricket. Yesterday, there was a match. We won the match. So, I was watching it, no, live. Sajivi Prakash, live. Court said, you are in the presence because you are watching live. He goes further. From a binoculars, you are watching at an elephant far away, bird in the far away. You are, because it is live, you are in the presence. And they said in the technology era, this is possible because, again, I repeat, the section Criminal Procedure Code, Tanka, you will agree, the evidence has to be taken in the presence of the accused. So the question arose whether Zoom evidence is presence. And if it is live, now some matches we watch later on the even the phone. Now that is not live, that is not presence. But if it is live, so most of the Zoom evidence when you take and cross-examine, that is live and that is construed as presence. And I love those two examples, watching the binoculars animals and watching a live cricket match. So very interesting, Tanaka, that.
I would remind our participants, if you have any question, you can put it on Q&A chat box and we can put it to our senior. And sir, but again, the Ministry of Justice is proposing a new SOP. In that, SGBV cases, examination in chief is going to be on video recordings.
What is STV, child abuse?
SGB cases mean gender-based violences.
Right.
In gender-based violence cases, they are proposing to get the evidence of the the main witness through video recordings.
Yes,
They
now
are
that is
going to prevent that witness being prejudiced in court, and again and again that procedure is being discussing.
now already, Tanaka, it is there for children. Evidence
Yes.
ordinance amendment came where the children, the recording by the National Child Protection Authority or anyone can be played. Now that is examination in chief.
Yes.
But how about cross-examination? How about re-examination? Now that has to happen. Now, to me, as a child right activist, I don't do child abuse cases, but as a child right activist, I have a problem. So when I am a state council, dear friends, very interesting things happen. Now I am a young state council. I can't speak to the witnesses. So like gender-based thing, we'll go to a child. I can't speak. So I'll give you a very interesting situation that happened. Now I can't lead the questions, right? Mokada une, what happened? Ambu Samiyan lesa hasuruna. I acted as husband and wife. Now husband and wife doesn't mean sex. So I'm now asking, Ambu Samiyan Mokad. Now what I wanted to answer was, penis was introduced to the vagina. Pushalinge, Strilinge, Pravishta Kara. Kian Memana is a lady. Young boy, you know. Not so on the Baritana Ahano, right? So Antimadama, Kumarpak Kiwahu, Yelakunarpak Kiwa, then Ekat Bani. The Mangano, the Hitan to Mao, Mangano, Ekian name Mokabda. Antimata, fortunately, judge came to my rescue and asked, Pushilinga, Srilinga, and their mother. Oh! Otherwise, it is not rape. So, in a way, recordings putting is a good thing. But there is one missed problem. You have to understand as a young lawyer, when you are bringing in a witness, the witness is not used to court. Not used to court. So what we normally do is that kind of a witness will ask, where did you study? Who is your father? Easy question that you can ask. So we make them used to the situation. And then ask the vital questions like rape or murder or whatever, whether you saw the accused, what light. Little later after they settled down, because most of the poor people are not used to giving evidence. Then Podilama, the women, if you play the recording, they might remember what happened. But then suddenly they have to face the cross-examination. They have to suddenly, boom, courthouse. That I have found it is not a very good thing to happen. That's my answer to that, Tanuka.
So, since elaborate on the presence of the witness, now we have seen demeanor and deportment of the witness is being considered very rare in present cases. Those days, I have gone through the briefs and previous judgments. Judges have noted the Sakshi garu handam in Sakshi, they like that. So. But at present, very rare to see the consideration of on demeanor and department.
It's very, very important because only the trial judge will know the demeanor and not an appeal court. That is the very basic principle of evidence. That an appeal court judge should not interfere with the demeanor and the credibility of the witness in that sense. Who watches it, who sees it is the trial judge. So, observations are very, very important. In my life, there have been very good judges who observe and write it down. You can't observe and give a judgment, that will become then hituakkara, arbitrary judgment. So they will record it, everything, right? But if you feel they are not recording it, it's not happening, then you can ask court, Your Honor, please, Swamini, Karunakala avasara දෙන්න මේ ඇසිරීම අකුණු කරන්න. He become very hostile. He's trying to attack the lawyer. Now that is good evidence for credibility, for biasness. So then you must point that to them and get it recorded. You have a right to get it recorded. And that is exactly what you should do.
So we have a question. Our friend is asking, is there a different criteria of evaluating expert evidence called from the defense and the prosecution? Is it the same
Yes.
criteria or a different criteria?
No, not at all. I'll give you examples and examples. There is nothing like that. Now, very interestingly, you know, handwriting is not a certain science like fingerprints. If you take expert evidence under section 45 of the evidence ordinance, to me, there is more credibility of an expert evidence who go by the slant and kind of thing. But there is evidence ordinance section 47, who is acquainted with the handwriting. That's very unique. For handwriting, there is not only 45, the expert who is EQD, examination of question documents, but there is someone else who is acquainted. I have found it's very, very difficult to challenge that acquaintance. මේ අස්සද මගේ අර ස්වාමියාගේ මම හැමදාම මේක දැක්කා. මට හොඳට අඳුර ගන්න. This is what is frequent acquaintance. I know it. That is very, very solid. So 47 is strong. But I can remember in Mr. Tilan Vijayasinghe's case about a bribery, about a small cheat, about writing down a bank account number. Mr. D.S. Vijayasinghe cross-examined an Indian witness on EQD for 21 days. And the case was broken. 21 days. That's what this is. I want you to look at Mr. Satasivam case. It is all on the expert evidence. How can scrape marks come on the helper unless he was on top of you. So the allegation was squeezing of the neck, Billa Birikaneka, was done by Sakasivam, not the servant. So who can get the hand marks on the face? Servant. So it is servant who strangled. All these are expert evidence. So either prosecution or defense. The objective is different. Prosecution is to prove the case. Defense is to attack it. Now, there was a case called Panadura Dias, where wife and the driver was charged for killing the husband. It was in the High Court of Tummulla at that time when I was a student. And I used to go and watch this. So there was, the important thing is time of death, marriage velana. Now, if prosecution is proven, time of death, they were in the house, husband, wife, and the driver. But defense called the witness and said, according to that, driver has taken the wife in a vehicle for shopping. So different timings, right? So there is no difference except the outcome. Prosecution is to prove the case. Defense is to create a reasonable doubt. Because very interesting, you have to understand, time of death is done by Sri Lanka, the Professor Seran, Dr. Seran, who was expert. Now, who is the person on the food you eat? How to tell the time of death? It is only the prisoner who was sentenced to death. Because there scientifically it is signed the time you hang, Elunga. And in every prisoner who was sent to Elunga has opportunity to eat anything they want. So it is recorded what they eat. So this was done by Dr. Disenam and based time of death based on food you eat was by him. So these are not very solid. Now the case of Pingami at that time, using a face to superimpose to the skull and say, this is the person who was, this is the person in the face, this is the skull. But at that time, when the question arose whether it's an advanced science, it's a science you have to do the experiment many, many times. And they come to the same conclusion. That is science. That is what is expertise all about. Now, the question arises. Imagine that, as this our viewer asked, imagine there are two doctors. One is an expert, he is an expert on murder. Other one is an expert not on murder. He has done more rape cases. Other one has done more accident cases. Then how your opinion, it depends on your experience. Kalapurutta. So that is critical. So now I hope we have answered, Tanka, the question. What is more important? What is more important? Is there a difference? No. But the qualification matters. The situation matters. Context matters. And I hope I have given the answer to him.
Yes, exactly, sir. Now, this is a rare opportunity to pose question to our senior, who is a lecturer of the Faculty of Law and our President Council, and you are getting very rare opportunity to make your questions. So you can feel free to make any question and type any question in Q&A box. We can put it to sir. Sir, since you brought this to different areas, actually the law of evidence is very vast. So you comment on the medical legal aspect also. Since until one of our friend, if they won't put a question, may I be permitted to ask you, so what is the relevancy of a short history in MLR? is it a very relevant part or whether we can omit it?
A very, very good question, because it's all depends on hearsay. Now, if it is a MLR, means medical legal report, that means the person is living. If you look at the post-mortem report, PMR, he is dead. That portion is not there. Rogiya visin dena keti itihasa. Now, I have seen so many cases, rape cases, murder cases, flopping, falling down because of the short history. Now, if the witness says, I know Ajit raped me, now he has told unknown person raped me into the doctor. Who is the first one after the police statement? It is the doctor. So how can it be doctor to say unknown and later says Ajit? Unless she has said that in the first state. So I have seen a lot of cases falling, crashing because of the short history. Because I have prosecuted in many parts. If you look at cases in areas like Ambalagoda, Gaul, Palapitiya, they exaggerate. They want to bring the whole family in. I'm using this area. This is where my experience is that they implicate everyone in the family. Finally, what happens? There is no injuries. Maybe one stabbed injured. Stabbed. But they say, short history says, sword and so many things. Khadu and all. It can't have a stab injury. And they will say, club, pulu. But the injury is cut. If it is puller, you need to have a blunt weapon. Blunt weapon only causes contusion. Telling. Teleno. Hama nilveno. Tuale nilveno. If you are living. So, most of the cases crashes because of the MLR short history. So, as a young defense counsel, you must always get, that is what you are entitled. MLR and the postmortem. You will have to look at the MLR. That's why Tanka's question is very, very important. When you are a criminal lawyer, defense lawyer, you have to be like an investigator. Same with the prosecution. You just can't, it's a very thrilling job. You have to be like an investigator, police officer. I'll take just one example. Now, it is a case about Attanagalla murder case. Attanagalla courts to Osman Gunasekara was shot. This one. He's in the news these days. This El Badra Padme want to kill him and blah, blah, blah. But his story of this case and everything will come in October called Father. Not Godfather, Father. Now, how did I get up? Now, the version of the prosecution is, I got a news that Osman Gunasekara is here. He came from Japan, came in a boat, killed and went in a boat. Right? So I had a very perfect alibi because he was in Japan, according to his passport. But forget that to you. Now the evidence is, no. Osman was in Sri Lanka. We got news, we chased behind, and he threw a gun, pistol. And what was pellets inside the body of the person, dead person, matched. Matched. So I asked Osman, make a win. He said, no, sir, not at all. Police could catch me. Now, how do you do? You have to be like investigator. I asked, okay, something has gone with the pellets. Dead body pellets were taken by the Nittabuwa police because this is Attanagalla courts. So it is put in a box, Nadubanda. Now, that is the pellet that was used. Nadubanda from there to come to the Gampaha courts at that time, because Attanagalla happened, they didn't want to hear the case in Attanagalla, they transferred to Colombo. Sorry, Gampaha. It took 3 days. 3 days. And then I checked up the incident of this pistol story exactly within the 3 days. Wow, got it. That means they took a pistol, shot, got those pellets, and change. Threw the other ones out, which is actual, and so I got him out from the case because of that. So you have to have a investigative mind, inquisitive mind, and you must get to a thrill. A criminal lawyer must read these thrilling books. Famous Criminal Diaries in Sri Lanka by Alice. He has all these series there. If you come to law college, you can read it and go. I will give you special permission. But there are books and books. Professor Ravindra Fernando's book on Satasi and a book on Matthew Perry's case. So you must get into this mood of Komadune, how did this happen? How did this happen? I will assure you, you will really, really, really enjoy. What is this evidence? How to find this evidence? You will enjoy as a criminal lawyer, but you have to prepare, study, ask people, ask seniors, sir, how can this be, sir? And you will enjoy, I can assure you, a life of a criminal lawyer with Tanuka and Naya. It's thrilling, isn't it, Tanuka? Are a thrilling job. Investigating, like Shania Besekar or whoever, people who investigate, you get that kick. Civil case, sorry, not that I'm running down civil. I think Tanuka is doing civil too, unlike me. So I enjoyed criminal law because of that thrill. I want you young boys and girls especially to get that thrill of criminal. Fun, thrill. Eka Marai. Life is beautiful. Yes, Tanuka, over to you.
Yes, sir. So we are running out of time, sir. We can continue this for too many days also. Anyway, sir, to conclude this point, sir. Sometimes doctors record the short story on their own language, and some doctors record the short story in the same language given by the victim.
Yes.
So, what is the applicability of those two? And is there a validity of recording a short story by the language of the doctor? Can we mark omissions or contradiction from the short story recorded by doctor in his language without
very
recording
good
the
question. Moment I have seen when we are trying to mark contradiction, because the heading is Rogiya visin denlabana ketiyate, the history given by the patient. Now you can say I asked from where and I wrote in my language. But then in a very tricky case, a very careful case, there can be problems. So if there is same wordings, what to do? I mean, doctor will say this word, what he said. So it is a very important thing. Like I know now, if you take section 110 of the Criminal Procedure Code, the statement that you give is reduced to writing. It's not the same words. It is reduced to writing. So ideally, we have seen when you put your own version like the police, the doctors, sometimes you miss the entire case. Miss the entire case. So what we are doing at law colleges, we are learning them crime scene. And we are allowing them to learn something new and move on.
Thank you very much. Actually, I can ask thousands of questions from you, and this is a rare opportunity I also get, and an important opportunity for me also, because I had an opportunity to discuss many questions, even I want to know. And thank you very much for elaborating us, sir. And since there's no question, I can hand over this to the host to conclude the remarks.
Privilege, Tanuka, as I told you, we both opposed to each other. And to ask me those questions, I find it a privilege. And Isuri and everyone within thank you so much for giving me this opportunity. And I'm speaking from the law college, as you can see from the outside, both sides. So it's a privilege that I'm sharing from Law College, the Law of Evidence. Thank you, everyone, Isuri, Vidurinda, and everyone for making this happen. And Tanuka for doing an amazing job. And we did it together, not one side. It was interesting. Thank you. Over to you, Vidurinda.
Thank you very much, sir. So this brings us to the end of the third webinar of the series on basics of law, titled Law of Evidence. I would like to take this opportunity to thank our esteemed panelist, Mr. Prasantalal Dialvis, President's Counsel, and our moderator, Mr. Tanuka Nandasiri, Attorney at Law, for the fruitful and educational discussion and for dedicating your time to be here with us and for sharing your insights. I must also thank the BASL Webinars and Legal Symposiums Committee for their dedication and hard work in organizing this insightful webinar. And last but not least, I thank all of you who joined this session today through various platforms and for making this discussion interactive. And thank you very much. And I hope all of you have a good night.